Supreme Court of Appeal today rejecting an application by the Ingonyama Trust for an application to appeal an earlier court ruling. That first court ruling found the trust was wrong to insist that people living on the land it controls must sign leases, essentially pay money to live there. The trust, you may remember, was created in the last days of apartheid. It controls a large amount of land in KwaZulu-Natal. The sole trustee is the king of the Zulu people. But it had been found that, unlike other communal trusts, it was demanding that people pay to live on the land it controls and that their families have lived on for generations. The attorney for the Legal Resources Centre, which brought the original application, is Sharita. Sharita, good afternoon to you, and thank you for your time. What decision has the court reached here? Why has it decided not to allow this appeal by the Ingonyama Trust?
Thanks, Stephen. Essentially, the court decided that there were very little prospects of success by the Ingonyama Trust board and the trust itself on the grounds on which it proceeded with the appeal, namely asking for the recusal of the two judges and for the matter to be reheard by new judges outside of the NPD.
You represent people who live on this land. What is it that you actually want? This court battle, and I don't think it's finished yet, Sharita, what is it that you want from this?
You're quite correct, Stephen. We also, as pleased as we are with this next step in the process, we don't believe the fight is over as yet. Essentially, what we want is the recognition and the protection for the millions of people that we represent who live on ITB-controlled land, in the sense that their informal rights to the land in terms of the customary law, their permissions to occupy, are recognized and given effect to, and they should not be made tenants on their land, which obviously waters down their customary rights as beneficiaries of that land. Their right to use and live on that land should be peaceful and undisturbed and should help them to improve their lives and to live with security of tenure. That is essentially what the clients that we represent are seeking to protect in this litigation.
So would I be correct then in suggesting that people who have lived on this land for generations, there are other trusts like this, there's lots of other communal land in South Africa, the Ingonyama Trust was demanding certain things from people that other communal land does not demand?
Yes, the trust was different in that way, peculiar in that way, in the sense that it was attempting to commercialize the relationship between the trust, the board, and the residents on the land, and, shall we say, invite a financial and commercial aspect to their tenure, which is not what the customary law provides for or that the Constitution recognizes. And this litigation was about challenging that departure from the free use and enjoyment of that land as beneficiaries, as they are, well, shall I say, entitled to enjoy. That's what this case is essentially about. It's making them lessees and tenants on land that is intended to benefit them.
There's a very complicated history to the Ingonyama Trust, and I deliberately included in my introduction the fact that it was created in the last days of apartheid. It's been strongly defended by the trust itself, the chair of the trust, Judge Jerome Ingonyama, if I remember correctly, strongly defended by one of the people who's instrumental in creating it, Prince Mangosuthu Buthelezi. Many people have been very critical of it, including the former President Kgalema Motlanthe, if I remember his high-level panel report. It seems to me this is going to go all the way to the Constitutional Court. Do you think we might find that the Ingonyama Trust Act is itself declared unconstitutional?
It's unlikely that it will be in the course of this litigation, but that is not to say that other applications may not be launched at later stages in order to challenge that act by a different application process. It is very early days. It may well be that the applicants, being the trust and the board, may find that there are exceptional circumstances in this matter which require them to launch further proceedings in order to get the matter to the CC, which then in all likelihood will remit it depending on the degree of success subsequent to this SCA order.
Sharita Samuel from the Legal Resources Centre, thank you so much. I'm sure there'll be more conversations to come on this particular issue. Well, let's update you.